Mr. Weiss.
Good morning, and may it please the Court. My name is David Weiss. With me is my colleague, Michael Rabia, and we're here on behalf of Rising Tide Development, LLC, and RTD Greenhouse, LLC, who just over 6 years ago applied to the Lexington Zoning Board of Appeals for a comprehensive permit to build a proposed 48-unit for-sale project on Lowell Street. The ZBA, after about a year of hearings, granted a permit with conditions that reduced the number of units approved to 28. 2 appeals followed from that. One was an appeal by a group of neighbors who, pursuant to Section 21 of Chapter 40B, brought an appeal to Superior Court challenging the grant of the permit. At the same time, Rising Tide took an appeal to the Housing Appeals Committee under Section 22 of the statute. And in that context, its burden is to show that the project as approved is uneconomic, and then the question becomes whether or not the limitations imposed on it are consistent with local needs. As is the usual course when there are 2 appeals taken in that context, the abutter's appeal to Superior Court was stayed, in this instance by way of an assented to motion, pending the outcome of the administrative process. The plaintiffs also sought to intervene at the Housing Appeals Committee. They filed a motion to intervene, which was ultimately not ruled on until after the end of the full proceedings at the Housing Appeals Committee, which included a site visit, 9 days of evidentiary hearings, and extensive briefing, all of which the counsel for the abutters, proposed interveners, participated in intensely, examined witnesses, cross-examined witnesses, and submitted briefs and argued. The outcome of the Housing Appeals Committee process was a decision which increased the approved number of units to 36. And under the statute and by the terms of the Housing Appeals Committee decision, that decision directed the board to issue a permit in accordance with the Housing Appeals Committee decision and said if it did not do that within 30 days, the Housing Appeals Committee decision
Mr. Weiss, let me ask you a question, please. If we accept your position, would that mean that any developer could eliminate a zoning appeal simply by pursuing an appeal with HAC?
Not at all. It's a very particular class of cases in which, in our view, the abutter's appeal is rendered moot. First of all,
so in some you could eviscerate the right of the abutter to appeal.
Maybe your argument is correct that it's quote rendered moot, but isn't the another way to look at this thing is clearly the legislature could not have meant when it allowed in Section 21 and said, abutters, assuming their person's aggrieved, and we got a whole, load of case law on that, have the right to go into the Superior Court and litigate de novo, correct, the whole thing all over again, because in Section 22 the applicant is given the right to appeal. Wouldn't it be better to construe what's said in Section 21 about Section 17B, or 17 in Chapter 40A, as simply creating a procedural mechanism whereby abutters can get into court? And once they get into court, cases are consolidated, and the overall standard of substantial evidence controls both proceedings.
Your Honor,
the legislature could not have meant to create these 2 diametrically opposite procedures that would delay these things forever.
I agree that the legislature could not have meant to create 2 procedures that go down separate tracks forever and produce a great deal of delay. It's very clear that the underlying theme of Chapter 40B is to expedite the development.
And the results of the 2 cases could end up in conflict. If
exactly.
They carry out to the end.
Let's put this in context for a minute and look at exactly what the legislature did do with respect to appeals, because I think it illuminates how the 2 should be related. First of all, in the case where the Housing Appeals Committee can make the biggest possible difference in what happens, that is, in a case where the zoning board has denied the application in its entirety, The only route of review provided is the appeal of the developer. After all, the neighbors aren't going to challenge the denial. The appeal of the developer to the Housing Appeals Committee, followed by, as the statute clearly says, review of the Housing Appeals Committee decision under the Administrative Procedures Act, Chapter 30A. In the situation where the abutters are most dramatically affected by what the Housing Appeals Committee has done, the legislature has said
You don't have any right.
your rights are to pursue the administrative procedure appeal, and that's adequate for you.
Let me ask you this. Assume that scenario, and the developer appeals, and the Housing Appeals Committee says, you're wrong, town, implement the permit, give the permit. And so the board does, or it's in effect considered to have done so. Is there anything that would allow the abutter at that point, because you've got a board action, to bring an appeal from that under 40A-17, under Section 21?
Nothing in the statute says that. That is, in substance, that action is the Housing Appeals Committee action. And the statute is clear that the route to review the Housing Appeals Committee is under the Administrative Procedures Act.
So even if the Housing Appeals Committee gave the board an option to either implement this yourself, or it will be considered to be the action of the board, if the ZBA in Lexington, or the Board of Appeals in Lexington, actually implemented it and entered an order allowing the permit as defined by the Housing Appeals Committee, you couldn't, the abutters couldn't appeal from that?
I do not believe they could, Your Honor. I do not think that the legislature intended, in the context of a statute whose purpose is to expedite this process, to say, first, de novo review at the Housing Appeals Committee. And it is de novo review at the Housing Appeals Committee. This Court has made that clear since Hanover. And then de novo review again of the outcome. That makes no sense.
What would prevent a Superior Court judge, if assuming these parallel appeals, what would prevent a Superior Court judge in the Section 21 appeal from hearing that appeal first, the abutters appeal first?
What traditionally...
And I know what the tradition is.
Okay.
What's to prevent a Superior Court judge from hearing the abutters appeal first?
Basic principles of administrative law that says the Superior Court should defer to the primary jurisdiction of the agency with expertise.
No, I don't think so. I think they can hear it in any order they want.
Well, I think they have the power to do that.
But the standard is the same, which is substantial evidence.
Mr. Weiss, do you think that your position is fair to abutters?
Absolutely. I think the legislature thinks it's fair to abutters.
Mr. Weiss, let me ask you this. Who moved to stay the Superior Court action?
It was we filed the motion, but it was an assented to motion.
Let's say there hadn't been an agreement.
I believe that we would have made the motion, and I believe it should have been granted.
Okay. Let's assume that nobody stays it. For whatever reason, they just don't stay it.
That could happen, Your Honor. I've never known that to happen. But that raises the specter, and of the two actions proceeding in parallel and with potentially divergent results. Now, I don't think there's anything...
Well, they're potentially, excuse me for interrupting you, they're potentially divergent, at least in this respect, that one of the things, and indeed happened in this case, is that the Housing Appeals Committee increased the number of units over what the ZBA had approved in the first instance, correct? So whatever record it is that the Superior Court is looking at, it's looking at something that isn't going to go forward anyway, correct?
That's correct, Your Honor. And that was the basis of the original motion for summary judgment that we're here on review of. But let me say this.
And that's another point on why 21 can't be construed the way the plaintiffs want it to be, because the upping of the units was done by the HAC, correct?
That's
by
correct.
the zoning board.
That's
So an
correct.
appeal from the zoning board is over something they didn't do.
And it's an appeal, the appeal from the zoning board action is an appeal of something that is no longer the operative permit.
Right. Has anyone looked at legislative history here on
We-
the meshing of these two provisions?
Yes, Your Honor. We've looked at legislative
Nothing?
history. We found nothing that was helpful one way or the other. We've looked at the other states that have somewhat similar statutes. Rhode Island's is by far the closest. They also have this parallel appeal process. but we can find no cases in which it's been addressed.
What do you say, though, to the argument of the abutters that, as in this case, their ability, number one, I take it their ability to intervene before the Housing Appeals Committee is the discretion of the Housing Appeals Committee. They don't have to be able to intervene, right? That's number one.
There is some discretion.
Okay, number two, as in this case, it's a limited intervention, so they
That's correct.
can't raise all their issues. So,
Well-
which they could have maybe raised in Section 21.
Good. Let's get right down to that. In this, there is discretion in the Housing Appeals Committee with respect to intervention. There is for every administrative agency. What occurred in this case, however, and this was common practice, this has been common practice before the Housing Appeals Committee, the abutters were allowed to fully participate. They were allowed to put in evidence on all the issues. They were allowed to file briefs on all the issues, to argue motions on all the issues, to cross-examine witnesses on all the issues. They did that. And it was only at the end of the day, so that the record was full with whatever it would take to adjudicate that matter. And we note in the papers that in their appeal from the Housing Appeals Committee decision, they did not attempt, and they did not argue, that they needed to supplement that record to put in an additional information. The record was complete. And the decision, in the final decision of the Housing Appeals Committee that awards them limited intervention, in one sense has no impact on their rights, because by that time, the record is complete on all those issues, and if the Housing Appeals Committee has before it evidence that bears on an issue, it takes that into account. And its
Mr. Weiss,
decision-
let me
I'm sorry, go
finish
ahead.
your sentence.
And the fact that they had limited intervention at the Housing Appeals Committee does not prevent them from being a person aggrieved who can take a 30A appeal, and they raised all the same issues in their 30A appeal.
Mr. Weiss, let me suggest this. Much of what the Housing Appeals Committee does has developed since 40B was enacted, correct? It seemed to me that one way to look at this is that a fair reading of Section 21, Section 21 is premised on the ZBA or the town, through its comprehensive zoning permit, issuing a permit. One way to look at this is implicit in that is that the permit will be satisfactory to the developer. So the developer is not taking an appeal. And therefore, an abutter or any other aggrieved person can take an appeal to the Superior Court because presumably the project is going ahead. Then you get to Section 22, whereas you say you have a denial or a grant with conditions which, frankly, from a developer's point of view, and I'm not using this in a legal sense, are effectively a denial because you've got this twin burden that you have to meet, that it's uneconomic. So de facto, from a developer's point of view, it's a denial. So from an aggrieved person's point of view, the thing isn't going forward. Why can we not construe Section 21 to say that, of course, an aggrieved person has an appeal if the project is going forward? If they want to participate under Section 22, they can move to intervene. And if it looks as though the Housing Appeals Committee is going to exercise what it has developed in case law, its right to tinker with a number of units, they can do that, as they did in this case. And, I mean, that they have a right to intervene. And then you go a combined 30A review from there.
Your Honor, that's very close to the position we articulate in the brief.
I know that.
That's the one I articulated at the start. 21 gives them standing in one of these proceedings to get in, whether if intervention's denied or the scenario.
But it doesn't give them standing in those circumstances, I would say, to go to the Superior Court.
Your Honor, there is one nuance.
I
in
mean,
that-
I see Judge Mills asked us right at the end of his little opinion, or asked somebody, would you please try and help us? I mean, you saw that little piece at the end of his opinion saying,
Yes.
I don't know why the parties would be in a better position than a court to figure out what to do. They wish to assist the court by providing suggestions as to how both parties can appeal. I mean,
Well, Your Honor, that's why we're here, rather than following the remand and back in Superior Court. But the one nuance, if I may, on the question of whether or not Section 21 applies only if
there is no appeal to the, if the project is going forward and the HAC doesn't even get involved.
Right. If the developer appeals to the HAC and the HAC says for one of a variety of reasons, we cannot go forward with this case, perhaps because it finds that, in fact, the town has reached 10%, so it can't modify it, then I think that would be another circumstance in which, in order for there to be some place for the abutter to go, they would be able to go.
Why would the abutter, if the town has denied the permit,
I'm sorry, if the town grants with conditions,
okay, grants with conditions, and HAC, so it's not doing it under the 10% rule, it's doing it just because it has a comprehensive permit.
correct. And
And
in
so
that case,
so that the developer is then stuck with whatever the, what did you ask for?
we asked for 48, the board gave us 28,
And so you're stuck with the 28?
correct.
The Housing Appeals Committee says, we don't have
we can do it.
jurisdiction because of 10%, and you're stuck with 28.
Right.
Then you're saying you could deem that as a grant under 21.
Correct.
It is a grant
Yeah.
under 21. The
No, but
key
it's already
point is
gone
that
to the HAC and come back down
The key point for
again.
your position, though, I think, is once you get in under 21, no matter which of these circumstances.
Under 22? 21?
No, 21. When a butter gets in under 21, no matter which of these scenarios we're talking about, the test, if it's one of these 40B proceedings, is substantial evidence, not de novo.
That, well, this court has said that it's, that in the Housing Appeals Committee and, of course, on a 40A appeal, it is de novo review, but the court has also said in Hanover that the test is consistency with local needs, and that's the standard at the Housing Appeals Committee, that's the housing at the ZBA, and the standard at the ZBA, and therefore must be the standard in a Chapter 40A appeal under Section 21 as well. It's the same standard everywhere.
Okay.
Thank you, Your Honor.
Mr. Whitten?
Good morning, Your Honors. May it please the Court. Jonathan Whitten, Barbara Huggins with me for the plaintiffs' appellants. Your Honors, a decision of the Housing Appeals Committee is a decision of an administrative agency and not the judiciary. To allow an administrative agency's decision to moot a statutory right of appeal.
It's not mooting it, Mr. Whitten. What is the difficulty with the suggestion, and Justice Glaney and I may be fairly close, which is to say implicit in 21 is that the project is going forward. It's been agreed to by the town and the developer. So there are really aggrieved people at that point. And there's nobody's taking an appeal to the Housing Appeals Committee, and you have an absolute right, and you're going to go into the Superior Court, and it's going to move ahead very promptly, and the town and the developer are likely to be lined up against you on the other side. But if there is a denial, or from the developer's point of view, an effective denial because it's uneconomic, he can't proceed, you do not have then there has been no approval for purposes of 21. You may, if you wish, seek to intervene, right? Because we're going to have a very different project. We're going to have a 36-unit and not a 28-unit for one.
Your Honor, respectfully, the project is not different. It's just additive. And in this case,
Well, it is in this case, but it might make a big difference.
It could, Your Honor, although
So you go in. I mean, I'm looking at a statutory interpretation. So you go in, and you seek to intervene because there is a possibility that something will be granted or be deemed to be granted, and you participate if you want to. In that proceeding, and then if anybody wants to take an appeal from that, they can. Why is that not a fair reading of the statute? Because as Justice Glaney said, the legislature couldn't possibly have wanted to have parallel proceedings that in fact are about different projects.
Respectfully to Justice Greene and to the Court, I think the legislature knew what it was doing and has left the statute alone since
Have
1960.
legislative history?
Not beyond the clear words of the statute, Your Honor, that the statute has remained unchanged since 1969. The legislature is presumed to have understood and for 40 years almost has seen parallel track appeals under 40A-17 and 30B.
I'm conceding you can have parallel track appeals. I'm just telling you or suggesting that the standard for either one, once you get through the de novo phase at HAC, is substantial evidence for both.
Your Honor, respectfully, the only important difference from the facts of this case is in appeal under 40A-17, the plaintiffs can bring to the Superior Court's attention issues that the Housing Appeals Committee will not hear, will not allow an intervener to bring forward. The Housing Appeals Committee and the presiding officer has broad, unbridled authority, as they did in this case, to deny issues of intervention specific to the harm articulated in 40B that this Court ruled in Standerwick that the plaintiffs sought to bring to the Housing Appeals Committee's
What kind
attention.
of issues, for example, would they bring that may not be brought to HAC if they don't intervene?
The most notable in this case, Your Honor, is stormwater runoff, stormwater trespass onto the plaintiff's property. It's in the record. The Housing Appeals Committee dismissed it by saying that can't possibly outweigh the regional need for housing.
But you could appeal from that, right?
You're-
You got to put it into evidence, right?
Correct, Your Honor. And under the 30A appeal, under the substantial evidence appeal, and the discretion to the administrative agency, the Court will not entertain a second guess of the administrative agency's
But
decision.
under the Section 7, at least the 40B version, at least as I read Jepson, yes, it's a de novo hearing, but the standard's going to be whether the decision was arbitrary and capricious, isn't
That's
it?
correct, Your Honor. That's absolutely correct. But the Court under Standerwick will allow the plaintiff to bring forward issues that the statute seeks to protect: open space, health and safety, site design, and in this case, it's health and safety. The plaintiffs sought to bring to the Court's attention at the trial level the impact of this project on their real property relative to health and safety. That is one of the cognized...
This wasn't raised in front of HAC?
Oh, it was, Your Honor. It's in the record.
Yes,
thought
it
that
says
you were
already
not-
been litigated.
No, Your Honor, it was not litigated in that it was not allowed, the interveners were not allowed to bring that, or were not accepted, that issue was not accepted.
But why wouldn't you have a right to appeal from that, and the Court could say, this is an interest that's protected by the statute, you're wrong, HAC?
Your Honor, because of the distinct burdens under 30A and 40A, and that's the crux of the argument and why the appeals court found, we believe, the way they did. Under 40A, the burden would be to prove, the board would move forward first to prove that the permit could lawfully be granted. Under 30A, the burden is on now the plaintiff to show that the administrative agency was wrong, and that's the substantial evidence test. That burden, that bar, is extremely high. More importantly, Your Honor, in the 30A proceeding, the rules of evidence are different, the burdens are completely different. The administrative agency, as this Court has said repeatedly, is presumed correct. The de novo hearing under 40A is there's no presumption of correctness.
But you've got an arbitrary and capricious standard.
At the 40A hearing
Yeah.
level, yes, Your Honor, and that would provide the statutory support, or would provide the plaintiffs with the statutory guidance that 40A, that 40B Section 21 allows. That is, you have a specific statutory right of appeal under 40A-17 with a far different standard than when you're in 40B Section 21, 22, and 23. The plaintiffs have a far, far different burden on the 30A appeal.
We know that, and we're trying to mesh the two statutes to arrive at one set of burdens and one set of proof.
And here's the suggestion, Your Honor, and I think the appeals court said it and then kind of left it at the end unclear. A 40A case, because it's a trial court, would in fact trump a Housing Appeals Committee decision. So where we could have a Housing Appeals Committee decision saying 36 units is approvable, the Superior Court could find on a de novo trial that, in fact, the Board of Appeals decision, as Justice Botsford said, was arbitrary and capricious. That would end the debate. In this case, the appellee received a permit for 36 units from the Housing Appeals Committee, but had a permit for 28 units from the Board of Appeals.
Mr. Whitten, may I ask you this? When a zoning board of appeals grants with conditions, grants with conditions, has a comprehensive permit issued at that point?
The approval is not a permit per se, Your Honor, because the permit hasn't been recorded with the municipal clerk's office.
Oh, doesn't Section 21 require the issuance of a comprehensive permit? I'm looking at the language that the legislature used.
Yes.
The issuance of a comprehensive permit says to me there's a green light to go ahead. That's where you get it.
There was an issuance, initially, the issuance of a permit was to allow 28 units. Wasn't that issued?
Well, I'm
Yes,
not.
yes, Your Honor.
It was issued, or there was a grant subject to?
There was a grant, an approval with conditions. The 20-day appeal period had not expired, and there was an appeal taken by both
Correct.
the plaintiff and
So there'd been no issuance. And I get back to my fundamental point. If there had been no appeal taken, then the comprehensive permit would have issued. Correct?
That's correct, Your Honor.
What you have now is a proceeding that's going on under 22 where the comprehensive permit hasn't issued. Correct? Because there's a whole bunch of other stuff that's going to go on between the Housing Appeals Committee that might order the board to go to whatever the 42 units. It might cut it to 36. It might say that they hadn't proved that it was uneconomic, therefore no permit. So your clients haven't been hurt at that point. When the permit is issued, maybe then you can take an appeal.
Your Honor, respectfully, I would disagree in that the language in Section 21, because it links to 40A-17, would provide the abutters 20 days from the board's decision to take an appeal. If, Your Honor, if that...
Of the issuance of...
Of the approval of the Board of Appeals decision with conditions.
Well, maybe we have to look at that language, but at that time, there's no green light for a permit, because I have a very hard time thinking that the legislature, maybe there were parallel tracks, but I mean, the very fact that there was a stay sought says to me that something else is going on here that shouldn't be going on. I mean, maybe what you do is just, no lawyer is going to risk, statute of limitations claims, so that you may do it on that basis.
Your Honor, on the 40A-17 appeal, the 20-day period, all permits issued in the Commonwealth approved by a board, Planning Board, Board of Appeals, Board of Health, would provide for an appeal period. So the language is consistent in 40B Section 21. If the plaintiffs hadn't brought an appeal within the 20-day period, they'd be barred. It would be foreclosed. So it would be an added burden. In fact, it would be really inequitable if the plaintiffs had to wait until the permit physically issued to then have to raise an appeal, which would be barred by the 20-day appeal.
I understand that it can't be that you don't have some opportunity.
Yeah, I agree. What if we had this, that we take Section 21, as I mentioned earlier, and maybe I'm the only one holding on to this theory, as a standing provision to protect your clients, people who are abutters, so they can get heard on this kind of situation, because it's a very important situation for developer, the town, and them. So we get two scenarios out of this. One is the town acts and the developer appeals to HAC, and you folks are either allowed to intervene or not allowed to intervene, but HAC holds a de novo hearing, correct?
Yes, Your Honor.
Yes, and presumably you're going to intervene. That appears to be the practice. At that point, if you bring your 21 appeal into court, substantial evidence. Now, if the other scenario that's just been postulated, the developer gets, the permit is approved, and he says, well, I can live with this, so I'm not going to go to HAC and try to prove, uneconomic and all that stuff. Your folks haven't had really any sort of hearing, so they can go into Superior Court and get a de novo, because there's been no de novo. Is that any possible reading of the statute?
Respectfully, Your Honor, I don't believe so, and here's why. The developer will always appeal to the Housing Appeals Committee when the Board of Appeals decision is for fewer units.
Not always.
Not always.
Not always.
In
Because
practice,
there's a very high burden. You've got to prove that it's uneconomic and.
Inconsistent with the needs.
Your Honor, in my experience in practice, that seems to be the case, but putting...
And partly what they're hoping for is exactly what happened for here, that they won't get as, excuse me, as few units as the CBA granted, and they may not get the maximum, but there's going to be some place
That's
in
correct, Your Honor.
between.
If you're right
That's
that
correct.
they'll always appeal, or they always are appealing, then I don't even need my second hypothetical.
Your Honor, I go back to, as the appeals court found, the distinction in burdens and the opportunities that the statute provides for abutters, for parties in interest under 40A-17. The 30A appellate process is simply not the same. It's far more prescribed. The appeals court made several findings based on how limited the abutters or interveners have their rights in a 30A process.
What's the exact wording of 21? Doesn't it say something to the effect that the abutters, or whoever they are, persons aggrieved?
Any person aggrieved by the issuance of a comprehensive permit or approval may appeal to the court as provided in section 17.
There you go. May appeal. May appeal means a right to appeal. Had they want to do what you want to do, they would have said may appeal under section 17, and all proceedings thereafter in the Superior Court will be governed by section 17 and cases decided thereunder are words to that effect. They simply created a right of appeal.
Mr. Whitten,
Yes, Your Honor.
may I ask you this? And I believe me, I know how tight the statute of limitations has been construed under 40A-17. But if you look at 22, right, and you have to go back to 40B-22. Again, 40B-22, I think, contemplates where the town and the developer are in a situation where the developer is saying, I cannot proceed. Right? I've either been denied or it's uneconomic. And a developer is not going to proceed if it is economic, if it is uneconomic. I mean, I think that's a reasonable basis for the statute. At that stage, no abutter has been aggrieved because the project isn't going forward.
Your Honor, may I respond? Mm-hmm. The project is going forward for the approval of the Board of Appeals decision.
I understand.
The developers...
This may not be very helpful to developers either, but what I'm suggesting is, and so for purposes of meshing 2122 and 40A-17, which is referenced in 21, the decision of the Board of Appeals for these purposes can only mean a decision when there's a go-ahead, namely there's an issuance of a comprehensive permit. It may be that if you don't have a statute of limitations problem, you then have a substantive appellate right to challenge. It may have gone to the HAC, it may have gone from, I'm talking about the developer and the board fighting, it may have gone then to the appeals court, it might have come to the Supreme Judicial Court, but you're not yet aggrieved until that permit issues.
I understand the question, Your Honor, and I think this was discussed earlier. If the abutter's right is preserved pursuant to Section 21 for a later date, then that would bring harmony to the appeals court decision.
So you don't even have to file. In other words, we're not staying proceedings. We're waiting until there has been an issuance of a comprehensive permit.
I understand, Your Honor, and if the statute said that, if the abutter world out there felt confident that that's what the statute said, then I think that would, Your Honor, bring harm.
Argument? And I thought I read that you suggest that. Maybe there's...
We do, Your Honor. We do. It's just the fact...
That's not the solution of the appeals court, correct?
That is not, Your Honor, no.
You were tagging on to the appeals court saying, come up with something that works.
That's exactly
It may
right,
not
Your
be what developers want, correct?
Your Honor, hard to say, because the Developers Forum is the Housing Appeals Committee, where the rules are for their benefit, the community secondary, the butters not at all. So the forum for the developer is the Housing Appeals Committee. This would create harmony with what I think the appeals court
But the
found.
delay is astronomical.
Your Honor, if I may, Your Honor, even though my time is up.
Sure.
The delay in this case cannot be attributed respectfully to the abutters.
No, I'm
No,
not,
no,
I'm just
Justice
suggesting if you
Botsford is saying-
adopt this procedure.
I agree, Your Honor, and that is part of, I think, the reason why perhaps the appeals court was looking for some harmony, because
But I think it's very difficult to see that when, I know you say it doesn't make any difference if it's 24 or 48, but it really does. It may be, for example, before you have the project, let's assume that you didn't have to stay it, right?
Yes.
You're fighting over a project for which no comprehensive permit has issued. I realize about the delay, correct?
I understand, Your Honor, and I think, again, if the abutters or the party in interest rights under 17 were preserved, and there wasn't the 20-day fear, for lack of a better word.
Let me ask you this, Mr. Whitten.
Yes, Your
Let's
Honor.
assume that we had a project yesterday which had something like 180 units.
Yes, Your Honor.
Right? And the town issues a conditional permit for, I'm not taking that case, let's say 50 units. No, not 150, 50 units. Much, 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 much smaller. Right? And you go into court under 4817 to challenge that. That's the condition. And the Superior Court judge doesn't want to stay it. Right? And you lose in the Superior Court. And then it turns out that, in fact, what happens at the Housing Appeals Committee, that a permit issues for, 100 units. And you sure as heck would have won on 100 units because you're claiming environmental impact or something. Serious. But the impact isn't going to be there for 50, but it is going to be there for 100. Do you have no rights?
In that case, Your Honor, which are not the facts of this case.
No, I understand.
But in that case, that really raises, again, the 30A problem, which is the abutters and why Your Honor's suggestion of harmonizing the statute.
No,
makes
do you
sense.
then a comprehensive permit issues? Do you then, there's another decision of the board?
Yes.
Do you have another 40A17?
Well, my brother suggested no, and I would agree with him. I think it would become a decision of the Housing Appeals Committee.
We have a floating decision of a Superior Court saying a 50-unit project, which nobody's going to build, doesn't impact the environment. It's an absolutely useless decision because
Yes.
nobody's going to suggest that. It can't be that that's what's required by the statute.
Your Honor, I would agree in that hypothetical. In the facts of this case, though, the aggrievement raised is just exacerbated by the Housing Appeals Committee's decision.
It may or may not be.
Well, in terms of the locus doesn't change, the stormwater issues don't change.
Well, that's this particular case, but
Yeah,
it could be
yeah.
another one where what you really want to do is cluster them all over at one end of the property, and the Housing Appeals Committee says do that.
Yes, Your Honor, that is possible.
Thank you,
Thank you,
Mr.
Your Honor.
Whitten.
Thank you.